Hello, and welcome to another episode of Car Brief. I'm your host, Richard L. Slager, a licensed attorney in the state of Illinois, and I have once again dredged up another tale of terror from the legal graveyard of automotive horror to bring to you another case. This particular one is Spagnoli versus Collision Centers of America, Inc. Let's rip into this, shall we? This is a case that was decided in August of 2017. This came out of the 2nd District Court of the state of Illinois. This was an appeal that was filed after a bench trial that proceeded. And in this particular case, the facts are as follows. This matter involved a 1966 Pontiac GTO that the plaintiff bought on eBay in 2006 for $32,657.02 for the purpose of a restoration. So far, so good. When the plaintiff received the car, he learned that there was unexpected structural damage to the vehicle. He received a partial refund from eBay, therefore. After removing the GTO's engine, transmission, drivetrain, interior, chrome, bumpers, lights, dashboard, door lock mechanisms, and trim, the plaintiff took the GTO to the defendant for restoration of the GTO's body. At the defendant's shop, the GTO vehicle identification number, the VIN tags, went missing. That's never a good thing. Never a good thing. The GTO parts plaintiff had removed before bringing the car to the defendant's shop were, get this, either sold by the plaintiff's former wife or destroyed in a fire. I'm telling you. Destroyed in a fire, I think that's probably the least likely thing that happened. I'm more likely to believe that the plaintiff's former wife sold the parts. What do you think? On June 29th of 2011, the plaintiff filed an amended complaint alleging various actions: conversion, in count 1, replevin, which means to get it's actually a taking of property and to try and get the property back, violation of consumer fraud and deceptive practices, injunctive relief, negligence, and damage to property. The testimony was heard during the trial, the bench trial held in February of 2016, and this revealed the following. The plaintiff testified that in August of 2006, he bought a 66 Pontiac GTO Tri-Power 4-speed convertible on eBay for $32,657.02. I don't know where they got the 2 cents from, but in any event, the plaintiff bought the GTO with the intention of having it restored to concours condition. Now that means bringing the car back to perfect condition as if it rolled off the factory assembly line. So bringing it back to as new condition. Actually, a lot of them are brought back to better than as new condition. The court just said this means assembly line condition to increase the value of the car to approximately $100,000. At the time of the purchase, the plaintiff had not seen the GTO, mistake number 1, but had seen photographs of it. When the plaintiff received the GTO, he drove it for a while, and then he realized there was structural problems with the GTO's floorboards, the frame, and the trunk. The seller refused to take the GTO back, not surprising, and the plaintiff filed a claim with eBay, and plaintiff received between $12,000 to $14,000 back from eBay. Now, eBay sounded like they were stand up in this particular situation, so hats off to eBay in that particular instance. Plaintiff testified that before he took the GTO to defendant's shop for restoration, he and his mechanic removed everything, quote unquote, from the GTO, including its engine, transmission, the entire interior, the chrome bumpers, lights, dashboard, door lock mechanisms, and trim. Then in November of 2006, the plaintiff took the body of the GTO to the defendant's repair shop. Plaintiff testified in 2013 his former wife sold or destroyed the GTO's engine, drivetrain, and axle. Lesson number 1, or lesson number 2 here. First off, don't buy something just based on photographs. Lesson number 2 is try to keep the parts of the car together. Wherever the car goes, all its parts should go as well. When you separate out car parts, things tend to get lost, or in this instance, sold off or destroyed by people that don't like you. When the body of the GTO was brought into the defendant's shop, however, the vehicle identification number, the VIN tags, were properly located on the GTO's firewall and A-pillar. But at some point, while the vehicle was in the defendant's shop, the VIN tags went missing. That's bad. That's really bad when you're looking at a collector car, any type of car for that matter, but more specifically a collector car. Well, there was an expert used in the case, an expert on restoration and value of 1960s and 70s muscle cars, and he stated that the restored vehicle would be worth $115,000, and the plaintiff's GTO was in pieces and a bare shell. He never made the determination as to whether it was a numbers matching car. A numbers matching car means that the VIN numbers match the numbers on the car's motor. These are the court's words. At the close of plaintiff's case, defendant moved for a directed finding, indicating that the plaintiff presented no evidence to support his claims, and the claims were barred by a doctrine called the Mormon Doctrine, economic loss, which in Illinois means that you can't recover for economic loss where there's no showing of sudden and calamitous damage to property. So that's it in a nutshell. It's a more complex doctrine than that, but I'm not going to get into the details in this excerpt here. There was another expert regarding classic car restoration and the value, and testified on behalf of the defendant that to bring the car to concourse condition means the vehicle has to be make sure you have all the original type equipment that was on the vehicle, everything from the frame to the inner trunk. Engine should be matching numbers, should be a numbers matching car, and it should look as if it rolled off the assembly line or better. The GTO's value was currently $4,000 to $12,000 in its current state. Well, the VIN tags were missing. That was a big no-no, and that impacted the value of the vehicle. This expert indicated if someone invested $80,000 to restore the GTO, it could sell for between $60,000 to $80,000 at an auction. On February 24th, 2016, the trial court granted the defendant's motion for a directed finding on those various counts, but they did find in favor of the plaintiff in the amount of $10,000. Well, let's see how they got to that. The plaintiff argued that the trial court made a mistake in the measure and calculation of its damages, giving him only $10,000. The award of damages was made after the bench trial and the standard of review. The trial court's judgment is against the manifest weight of the evidence. That's what the plaintiff's argument was. The appellate court didn't agree. They said that the plaintiff claimed that the trial court should have awarded him damages under a contract theory, that under that theory he was entitled to expectation damages or lost profits consistent with the value of the GTO restored to concourse condition. Well, here's the problem. Those VIN tags were missing. Problem number one. Problem number two, well, guess what? The ex-wife threw out the engine. So it's no longer a car that could possibly ever be matching numbers because the engine's gone. So the court took that into serious consideration in making their decision. Because lost profits are prospective, lost profits will, to some extent, to be uncertain and incapable of calculation with mathematical precision, and they're addressing the missing VIN tags here. How do you establish the value of a car when its VIN tags are missing? But to recover such profits, the plaintiff need not prove the amount of loss with absolute certainty. That's fine. However, recovery of lost profits cannot be based upon conjecture or sheer speculation, and in this case, there was a lot of speculation going on as to what this car would be worth without its VIN tags and without the engine and all the parts that were stripped off of it to get the body back into good shape. And one of the experts, or actually one of the defendant managers for the shop, indicated the car was terrible when they brought it to him. They said that the floorboards were held together with roofing tar and 2x4s, and when you lean on the A-pillar, the whole thing would shake. It was in terrible condition. The body was just, it was appalling. Let's see, the testimony revealed that the trial court found the VIN numbers went missing while the GTO was in the defendant's possession. However, the loss of the GTO's engine is another matter. So here they get to the issue of the engine. The plaintiff testified that he removed the GTO's engine before delivering the GTO's body to the defendant, and that the plaintiff's ex-wife sold or destroyed the GTO's engine. That's just killer to hear that. I'm not surprised, but it's just along with the GTO's other parts. Thus, the plaintiff failed to establish the defendant's breach, the loss of the GTO's VIN numbers caused by a specific portion of lost profits, and therefore the trial court's decision not to award the plaintiff lost profits was not against the manifest weight of the evidence. So the plaintiff couldn't prove lost profits because of the missing VIN numbers, but what he could show was that there was a bailment situation where you entrust your goods to another for their benefit. It's also for your benefit, and they do something bad or they do something wrong with the goods, causing the goods to be somehow destroyed or wasted or diminished in value. They're going to be responsible for that. So the court did the best they could, and they awarded the $10,000 that they felt was a fair and appropriate compensation in this particular case. Plaintiff did not prove their case. They couldn't show how he lost profits and the potential value of the car had it been fully restored, and that was pretty much the end of the case. The court wasn't going to overturn what the trial court awarded in the amount of $10,000. All the other actions were dismissed. Consumer fraud wasn't shown. There was no showing of negligence as far as the negligence cause of action with regards to lost profits. That was shut out by the Mormon case. The Mormon doctrine didn't allow any compensation there. So the plaintiff basically, he got $10,000 plus he got some money back from eBay earlier on, and that was the end of the case. Well, that's the outcome. That's what happens when you buy something online. You don't actually see the vehicle, you don't test drive it, you don't inspect it with your own eyes, and that also happens in the case of divorce or disgruntled ex-spouse, who will throw away your car parts to hurt you where it hurts most. And what can we take away from this case? Well, my submission, as I have said in earlier analyses, make sure that you get somebody out there that knows what they're doing. Look at the car, at least have a set of eyes to look at the vehicle before you buy it. Secondly, if you're going to dismantle a car and take it apart, keep the parts with the vehicle as best you can. Let the parts follow the vehicle. Because when you store them in an off-site or off-premises location, somebody else may get their hands on them and they may mysteriously walk away, grow legs, walk away and disappear, as it was in this case. Because when things went south in that marriage, well, so did the parts. They were probably destroyed or they were sold at a fire sale, and that was the end of that. And the car was never going to be reunited with its internals. Lost all its internal organs. It was fatal to the car, and ultimately it was fatal to this case. No matching VIN for the engine and missing VIN numbers. The VIN tags went and grew legs and walked away, so the car basically just died. It's kind of a sad case, but we do have a resolution, and now the air is clear, the rain has stopped, and the clouds are gone. The sun is shining, and once more until another set of storm clouds form on the legal horizon in the form of another classic automotive terror story from the legal graveyard of automotive terror. I'm Richard Elsager, your host of Car Brief, and I bid you happy motoring and drive defensively. Until the next case. Take care.